Good morning, everyone. Welcome to everyone here in Carson City, as well as anyone in Las Vegas or those watching online today for this Assembly Judiciary meeting. Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Marzola. Present. Moore. Here. Nadeem. Present. Orenlicker. Here. Roth. Here. Urick. Here. Chair Miller.
Here. Hi, please mark Assembly Member Dahlia absent excused, and please mark Assembly Member LaRue Hatch present when she arrives. With that, just a few reminders. We ask that everyone turn down the volume on their electronics. We also want to remind everyone that before speaking today to please state your name. And the first time you state your name, please spell it so that we have it correct for the record. That would include anyone presenting a bill, testifying, or making public comment today. For testimonies and public comment, we ask that you keep your remarks to 2 minutes. And for anyone presenting a bill, we ask that you keep your presentation to 15 minutes. We do have a call-in option for those who choose to testify or call in for public comment. The phone number is 1-888-475-4499, and the meeting ID for today is 811-5366-6594. And that is also available on the agenda that is published on Nellis today. Again, you can watch today's meeting through our Nellis channel or through the YouTube station, which also just make sure you're under the Assembly. With that, we will go ahead and begin for today. Our first bill is Assembly Bill 159. It establishes the Hope Card program for applicants who have been granted an extended order for protection against domestic violence. And so with that, Assembly Member, I'll give you all a few moments to get settled, and whenever you are ready, please proceed.
Thank you, Chair Miller. Good morning, my fellow distinguished Judiciary Committee members. I'm Melissa Hardy. I'm the Assemblywoman for District 22, and I'm honored to be here this morning to present Assembly Bill 159, which aims to provide a vital tool for survivors of domestic violence called the Hope Card program. And I am honored to have with me today Liz Ortenberger from Safe Nest as well. As members of this committee know, domestic violence remains a persistent and devastating problem in Nevada. Unfortunately, we hear statistics that we are probably one of the states that has the highest incidence of domestic violence, which is a very sad, but it's realistic. And so countless individuals live in fear, navigating the complex legal system to secure protective orders that provide a semblance of safety. However, while essential, these orders can be difficult to readily produce and verify in everyday situations. Hope Card programs directly address this challenge, which first appeared at the statewide level in Montana in April of 2010. Hope Cards provide concise information regarding a protection order. They typically include the dates of issuance and expiration of the order, information about the issuing court, information about the protected parties, and identifying characteristics of the person against whom the order was issued. This ensures law enforcement is not wasting precious time trying to track down paperwork, and victims with orders are also less burdened with stacks of paperwork and can more easily carry and access proof of the protection order. While TPOs are meant to be in a searchable repository, sometimes that is either not accessible or there can be a delay in entry. So the Hope Card would provide a physical or digital means the survivor could show to police or in other situations like to an employer or a landlord, even a neighbor or at a school, to show that they do have a protection order against an individual. So at this time, I will go through the key components of AB 159. So Section 1 establishes the Hope Card program itself, outlining the responsibilities of the Office of the Attorney General in developing and administering the program. The Hope Card must include important information, as I mentioned, the applicant's name, date of birth, details of the extended order, and the issuance and expiration dates. It's a wallet size. It can be in digital or paper form, and there wouldn't be a fee charged to the person seeking the card. Section 1 also addresses potential misuse, establishing that a person who knowingly presents a fraudulent or expired card to another person with the intent to falsely represent they have an extended order would be guilty of a misdemeanor. And then Section 3 requires the applicants for the extended order to indicate in their application whether they are requesting a Hope Card. So this would streamline the process and would ensure that those who would like the card can do so easily. And Ms. Ortenberger can give you more details about TPOs, but initially a TPO can be for 45 days, and then the Hope Card is for extended extended protection orders, and those are granted by a judge, and which a hearing allows both the victim and the adverse party to present their evidence, and then the judge decides if they're extended. So I'll turn it over now to Ms. Ortenberger for any additional comments, and then we'll take questions. Thank you.
Thank you. Liz Ortenberger for the record, LIZORTENBURGER. I am the CEO for SafeNest. SafeNest works with survivors on about 3,000 temporary and extended protection orders every year. And what we see in the field, quite frankly, is the adverse party dodging being served with the extended protection order, which means that extended protection order then does not go into the repository. And if a victim who is being stalked or harassed by their perpetrator in violation of that order has very little protection because police can't look it up in the database. A Hope Card issued at the time that the extended protection order is granted allows that survivor a layer of protection so that they can quickly verify with law enforcement, should they need to, when the adverse party is violating that protection order. The small card provides convenience and clarity for survivors, and it is, again, just like the bill we'll present after this, one layer of protection for our survivor community. We ask survivors to do about 150 different things when they report they're in a domestic violence relationship. Yet, as a community, we provide very, very little in way of ease of those processes, and this is one step that we can provide as a lawmaking body to make this pathway somewhat easier for survivors. Thank you.
Thank you. And if any of you have ever, dealt in the court system and, come away with your file or your documents, I don't know many that would carry all those documents around. And so this, as we've presented here, is just another tool and a way for a victim to show that they have an order in place, and it gives them a sense of security and allows others to know, that they have this. And, maybe a family member or at a school or someone can contact law enforcement, on that person's behalf just by simply showing this card. So we'll take your questions now.
Okay, thank you for your presentation. Our first question will be from Assemblymember Gonzalez.
Thank you so much. Thank you so much for the presentation, and I definitely understand the intent here. I would agree, we do ask our victim survivors to do a lot of things, but I do have a few concerns with this bill. But for, the rules of our committee, I'll ask one question. So you stated in your presentation that this would be a card that is issued at the time that the extended protection order is granted. And I'm trying to find it now. I read this the other day. I thought that, or I guess I just am wondering for some clarity, does the person have to request this, or is it like an automatic card? And then I'll have a follow-up if we have time for follow-ups. Thank you.
Liz Ortenberger for the record. It's requested on the application. So when they're filing for an extended protection order, they would mark that they would like a Hope card.
Thank you so much. So I guess I'm kind of wondering, so where does the Attorney General come into this? Because if the victim survivor is asking for this at the time of a protection order, they're in the courts. And if we're wanting to limit the burden on them, so are they now having to go to the Attorney General? Does the Attorney General deliver it to them? Kind of walk me through how the actual, that would look. Thank you.
That I have talked with the Attorney General. Melissa Hardy for the record. Spoke with the Attorney General, and they are supportive of this and say that they would have no problem managing this. And so how that, I was hoping they would be here today, but they can certainly answer questions about how that would work. Oh, okay. How that would work, because to your point, we want this to be ease for the victim, and not make them jump through any more hoops. That's not the intent of it. And so, yeah, I'm sure that they can speak to that. Thank you.
Assemblymember, did that answer your question, or do you still need clarity?
Yeah, sorry.
Okay. Chief of Staff, Benitez Thompson, would you approach, please? Thank you so much. Not giving you any time to pull it together, but she's an old pro, so.
I just wanted some clarity on that
Could
process.
you repeat the question?
Yeah. So so in the bill it states that the Office of the Attorney General would administer these, but then the victim survivor would ask for this card while they're filling out their extended protection order. And so I'm wondering, right, as a victim survivor, would I then have to coordinate with the Attorney General office? Would you be sending it to the courts and then I go pick it up? Kind of like, what is the process? Because I'm kind of just a little confused on that part. Thank you.
Thank you so much to Assemblymember Gonzalez, through Chair Miller, Teresa Benitez Thompson, Chief of Staff. Thank you so much to Attorney General Ford. So we would figure out what that process is, and we would work with our partners, especially our judicial partners, to figure out at what point it's the right time for our office to issue that card. We want to speak to the fact that we think that this is reasonable and we can figure this out. This is not an insurmountable ask for our office logistically. We can make a plan and pull this together.
You're welcome. Thank you. And we may just call you right back up, so. With that, our next question is from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. I do have a question about the logistics of this. And you said that the Hope card can either be a physical card or it can be digital, and that it's something that's requested at the time that they're asking for an extended order. Survivor victims, a lot of times when they're going through this, they're not really thinking clearly, especially because you have to go to court and face the person that has been abusing you. Why not encourage the victim survivor, or when they get the card that has like the information on how to get a TPO, to scan that a TPO, an extended order, on their phone?
Liz Ortenberger for the record. So I always think it's important to remember that women living at and below the poverty line are 5 times more likely to be victims of abuse. And so sometimes how that translates and what we see in our world is scanning things, getting things in your phone. Let's also remember the phone is usually the thing the abusive partner takes and smashes. There is a lot of concern in a survivor's space and a lot of access to things that normally, yes, I can scan something into my phone and it's no big deal, but in these situations becomes more complicated. A wallet-sized card, if they receive it digitally, they print it out, cut it to the right size and put it in in whatever they're using, or they take a picture of it and put it on their phone, is much easier than scanning in the entire protection order. The other thing that happens on the scenes of domestic violence phone calls very often is the abuser has taken or has hidden their electronic device, so police are unable to find or have access to. If that adverse party hasn't been served, it's not in the repository. So a survivor is the best person to dictate for them what works best. If that's having 5 paper copies of this hidden all over the house, so if there's a violation, I can find one of those and give it to police, or if it's digitally having it on my phone and I know that that's a safe space for me as a survivor, we have to create options and empowerment in the space so that survivor can do what's best in their scenario, which is why it's digital, or you can receive it laminated, I believe, is the other option. So honestly, like what I see every day is survivors are their best advocates, and giving them as many options to stay safe is the best option.
I'm also curious if you're able to answer this. How many other states have this type of program?
So I was able to locate 7 states that have this program. Indiana and Washington were the 2, I think, that sort of spearheaded this several years ago. And those are also states that we can look for should there be an amendment around, is it the AG's office, is it the court administrator, how are these things being done efficiently in other places. But there are 7 states that I was able to find that currently have this program.
Melissa Hardy for the record. Yes, there are 7. I was told 10. So there are those, and there are, in addition to states doing it, there are municipalities that also do it. I found this from Florida, so I know that they have this program there.
You're welcome. Thank you so much. Our next question is from Assemblymember Cole.
Good morning. Thank you for bringing this. I think this is really important and will be very beneficial. So my question is related to this being limited to domestic violence. And so, and I don't know how broad this would be or how big the fiscal note would grow if you swept in more, but does domestic violence include the threats of domestic violence, or when you're concerned about maybe something happening to your children?
Liz Ortenberger for the record. So it's important to understand this bill only covers extended protection orders. So the TPOs, which are much higher quality, and then emergency TPOs that are only available in Clark County are not included under this. The reason for that is, as Assemblywoman Hardy said, is temporary protection orders are 45 days in length. They can be renewed, but extended protection orders can last years. And so having the card is helpful. In terms of expanding the reach, I think that will be a conversation, I hate to say for next session because it feels so far away, but I have found in Nevada what works really well for us is if we start something kind of at the most important nexus, which selfishly for me is domestic violence, and then get it working well, and then look to expand it in further sessions is a very good strategy for our state.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for being with us this morning. So my question is, if these cards are helpful, and we also established that some survivors are not thinking clearly right in the moment, I'm wondering why this is upon request and maybe not automatic that you can opt out of.
Liz Ortenberger for the record, sort of similar to what I said before, survivors are their best advocates. And most extended protection orders are worked through with an advocate or with legal advice. So there's somebody there, but if I know it's best for me not to have this kind of documentation because of my survival, I need to be able to make that choice for myself. And SafeNest is a huge proponent of survivor empowerment, and this falls in line with that value.
And I appreciate that. And so my question is just, as far as process goes, are you envisioning that when they are going through this paperwork, they'll be asked, do you want this, yes or no? That'll be part of the questions?
Yes.
Okay, thank you.
Sorry, Liz Ortenberger for the record. Yes.
Thank you.
I just wanted to follow up a little bit, Melissa Hardy. As she was saying, when you initially get a TPO that is for 45 days, as we've mentioned many times, these are very emotional and volatile situations, and this is usually with someone that you're in a relationship with, you may have children with, and all that. So it's very emotional, and so that's why the initial order is short. And then when you want an extended one, now you're going to a judge, and you're working with someone and working through all of these things. And sometimes victims decide, no, I don't want the protection order. They go back to the abuser. So a lot can change, and so that's why we wanted, this is for the extended order, because then that gives them a little time away from the incident, and then they can work through, do you really want this, and where is that victim in this whole process, working with an advocate or an attorney to decide what they want to do.
Thank you for that. Our next question is from Assemblymember Urick.
Thank you, Chair. Thank you both for the presentation and for bringing forward, I think, is going to be a very helpful piece of legislation. I'm going to draw my experience as a police officer, wherein why I think this would be so helpful. There are a lot of times the violations of these orders come late at night, on weekends, and obtaining copies to confirm that this exists, to establish probable cause, to make an arrest, were challenging. So I love the concept here, but as I was going through the bill, it talks about the types of information that's going to be available, and then I look at subsection 4C4, it does provide that any other information that the Office of the Attorney General deems appropriate. Because a lot of the information that's listed there didn't provide, or would not have provided me as a law enforcement officer with some of the specific details that are often included in the protective order, specific distances, locations, things like that. Is your vision that this provision or this portion of the bill would cover and contain those details? Because a card telling me this but doesn't have the details I might need to enforce that order could, limit its effectiveness. So can you just address that for me?
Melissa Hardy for the record. Thank you. Yes, and that was my is my understanding of any other information, and so maybe that is something like Chief Benitez Thompson said, as we develop this, that we can determine what exactly, and that's a great suggestion of what is the distance of that they're supposed to stay away. So I appreciate that suggestion.
And I will follow up on the Assembly member's question. With that, then would there be room for, when the Attorney General does something, that's for the entire state, but sometimes different jurisdictions or municipalities, there's certain things that are unique to each community. Would there still be the flexibility for that to be included as well?
Melissa Hardy, are you? I'm not sure I understand
So
the question.
for the question that the Assembly member just asked about including other additional information, and that the Attorney General would have the ability to do that. So when the Attorney General does something, that's going to apply to the entire state. However, there are some times where certain municipalities or jurisdictions or communities, there are things that are unique to different communities. Would there be the flexibility for additional requirements to be included or to be adapted toward our community needs?
Okay, yeah, Melissa Hardy. Yes, I mean those are things we can work out with the Attorney General. How flexible or adaptive like they need to be, like you said, for each jurisdiction, or what information you want on them. I've seen examples of Hope cards that have, the protection order extends to children and the children's names are on there. Maybe somebody wouldn't want that, but that's kind of what I've seen and what I would envision that we can work with the AG's office to figure out, is it a form and you put in what you want on that for a particular card, but then some standard information for all of them.
Liz Ortenberger for the record. I want to add one of the places we see the largest violations in this is in schools. So the adverse party is supposed to stay away from the school where the children are. The victim goes into the principal's office or into the administration office, and they are asking, how do I prove that, right? Schools are very reticent to get involved in these kinds of situations for all the right reasons. But the card with that information on it, having the school listed as an address. Of course, there's only so much space on a card, and it may be that as we progress in this program, there's an actual, a barcode or a code that the victim can pull up to show all of the places the adverse party. As we do all the emergency temporary protection orders for Clark County, I can tell you sometimes there are up to 35 locations the adverse party is not allowed to be within a reasonable distance of, to protect the victim, but also a lot of times children are involved. So this can get very complicated. There's only so much space on the card, and I think because there are 10 states that are doing this, we can pull from some of the best practices and work with the AG's office to make sure that the critical information is on there, and then move forward in future sessions.
Thank you for that. And so I heard 2 points, one being that even for specific community adjustments, it will still go through the Attorney General's office, which I appreciate. And the other one is I just want to make sure, again, because of our rural communities, our tribal communities, we have people that live and coexist between tribal land and other land. So I just want to make sure that everyone would be covered and those flexibilities would be available. So thank you for that. Our next question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. My question is just procedural. How is the process of obtaining the card impacted if the extended protective order has not been served on the adverse party?
Liz Ortenberger for the record. So my understanding from the conversations that we've had is the card is available upon the judge granting the extended protection order, because one of the issues that is evident in the space from SafeNest's lens is the adverse party evades being served, and then the victim has no protection because it's not in the centralized repository. And so law enforcement can't look it up until the adverse party is served.
Thank you for that. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. So my question is, if we see the data from other states, what do you see how the Hope Card helped the victim in the other states?
Melissa Hardy, thank you for the question. In reading about this and researching this idea, everything that I've read has showed that it's helped a lot because of all the reasons that we've mentioned. If it just shows that this person was granted a TPO by the court, it's easily accessible. They may be going to a mall or going somewhere and like we said, not carrying the copies of their TPO with them. Something happens and it's readily accessible for them. And it helps, as we've mentioned too, show law enforcement if that's not accessible to them for some reason. So everything I've read, it's been easily implemented, and victims have taken advantage of this, and it's been very helpful. And it's helped them feel protected and feel safe. So, yeah, I haven't seen any reports of it not working or having any negative effects.
Thank you.
Thank you so much. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. Good morning, Assemblywoman Hardy. Good bill. I'd actually like to see it, expanded to all, people that have restraining orders, extended restraining orders. But question I have is probably more technical. So we've talked about privacy and stuff and, what's going to go on there, especially when you talk about the 35 different restrictions. Could we just simply, have the card with, and this is a technical question, but could the card just actually just identify the victim and then have a QR code where the officers can scan it and they get everything they need?
Liz Ortenberger, for the record, I absolutely love that idea. I think that would require more technical infrastructure than we have prepared at this time for the bills. And again, I don't think we see this as a stopping point. We see this as an evolving point. So yes, how do we create a connection point, knowing that QR code without some protection around it could create an opportunity for violations of privacy and all kinds of things, should that card fall into the wrong hands, for example. So I think there are definitely some nuances to figure out. What we're seeing mostly in other states is simply a card printed, that there is a protection order, extended protection order, this is the date of expiration, and pretty minimal information on the card. But we can do more research to figure out what that looks like. And again, I think this evolves. This is not a stopping point. This is a starting point of providing really important protections for survivors.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you so much, and I really appreciate the intent of this. My question is, and I think maybe I missed it, so would an officer still have to verify the information on the card, or, yeah?
Liz Ortenberger, for the record, the intent is that the survivor can show the card and then the adverse party is dealt with as is appropriate by law enforcement recommendations. I think what's important to understand, as we've done ride-alongs and worked closely with Metro over the years, the scenes of TPO violations are just as chaotic as scenes of initial domestic violence 911 calls. There's oftentimes screaming, crying, just chaos, right? And so what we want to do is make this as easy as possible for the officer to do what they have information for to mitigate the situation as quickly as possible. So the anticipation is that the officer would be able to look at the card, see the adverse party, see that there is an extended protection order in place, and act accordingly to their policies.
Thank you. Our next question is from Assemblywoman Moore.
Thank you, Chair. I have a question about how the card, you're going in as the victim survivor, you're filling out the paperwork, and you see the checkbox where it says, would you like a HOPE card? How would a victim survivor know what a HOPE card is? And how will they know that this will be another tool to help them?
Liz Ortenberger, for the record, my guess will be that it will say HOPE card and it will say a wallet-sized documentation of your extended protection order to give it context. So for a survivor that's filling that application out without any advocacy or support, that would be a quick definition and potentially even a link to understand more if AG's office were to put up a web page that explained the program so that they could get more information if they needed it.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. Appreciate this bill very much. One thing I found interesting, you mentioned in your opening comments that this idea originated in Montana in 2010, and so many other states have done this. But what was interesting to me, and especially since I have a lot of tribal groups in my district, this originated with the Crow Nation in Montana, so it came out of a tribal nation. And on the basis of, I usually have a lot of concerns about, let's let the state stay out of the way of municipalities and such. But then we know that there are things that the state does do and that we need them to do. I can say from personal engagement I've had with my constituents in those 6 rural counties that domestic violence, unfortunately, knows no boundaries, and this is a statewide problem for sure. My question is, when we talk about, I'm glad to see the support of the AG's office because it is a statewide program. We'd see a lot of these mechanics work out in the regulatory process. Is that right? Is that how that would work?
Melissa Hardy, yes, thank you for the question. Yes, so as Chief Benitez Thompson said, we can, address how all the specific works, what we want to include, how they would know what a Hope card is, all of that. Because we sometimes walk a line when we're doing legislation of being prescriptive enough in the bill or being too prescriptive, and what needs to be done, and also if there needs to be adjustments as this develops and progresses, and if there's too much prescription in the bill, then we have to wait and come back to legislative session. And so a lot of that can be worked out if the AG is the one that does this program. Then that way, if adjustments are need to be made, or then we can do it that way.
Thank you so much. Vice Chair Marzola, did you have a question?
Thank you, Chair. I did have two questions, but my colleagues all asked some amazing questions. But if I could just make a request, Chair. First, I want to say thank you so much for bringing this bill. Safe Nest holds a special place in my heart, and so whenever you're here, I love that. But my request is, you guys stated that there are about 7 to 10 other states that have implemented the Hope Card. If you can give that information to the committee secretary so that the entire committee can have it, and we can go through and see what has worked and what hasn't, we would appreciate it. Thank you.
Melissa Hardy, yes, absolutely. We can get those to you, and like I said, you can, even some of the states have put on, the card, an example of the card that they're using, so you can go and look at that. Florida, Montana, you can actually see the card and what's on them, so we'd be happy to do that. Thank you.
Thank you so much. At this, excuse me, at this time, I'm going to open it up for testimony. We will start here in Carson City first. Again, I ask that everyone say their name and spell it so that we have it for the record. And also, please keep your comments to 2 minutes. So we will begin here in Carson City.
Good morning, Chair and members of the committee. For the record, my name is Serena Evans, SERENA-EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. We support any measures to reduce barriers and help empower victim survivors, and so we're appreciative and support this bill. Thank you.
Good morning, Chair Miller and members of the committee. I'm Alex Canito, ALEXCANNITO, with the firm Womble Bond Dickinson, formerly known as Louis Roca, on behalf of the Domestic Violence Resource Center, and we are in support of this bill. We support efforts to allow law enforcement easier and quicker access to confirm protection orders, especially in time of crisis. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, JASONWAOKER, representing the Washoe County Sheriff's Office as well as the Nevada Sheriffs and Chiefs Association, who cannot be here today, supporting Assembly Bill 159. I believe it would be a good program as well as potential good groundwork and hopes to get us to legislate an option of electronic service of protection orders in the future. Again, supporting.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. We are in support of AB 159 and appreciate Assembly Member Hardy for bringing the bill. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson, CATHCART. This program will assist our officers in the field, and we're very supportive and thank the sponsor for bringing the bill. Thank you.
Hello, Chair and Council. For the record, Jessica Glover, JESSICA, Glover, GLOVER. From my experience of domestic violence is I have what is called the CAP card. The CAP card ensures that instead of giving out my physical address, I give out the CAP program address to receive my mail. However, it needs to be all efficient with the Hope program, the Hope card, and the CAP card, because from my experiences, I've recently found that my mail is not being received through the CAP program. So the Hope card and the CAP card all together, it needs to be established the survivor victim is being protected 100%. Thank you.
Thank you so much. Is there anyone else here in Carson City that would like to testify in support? I don't believe there's anyone in Las Vegas. So with that, broadcasting, will you please open the line?
If you'd like to testify in support of AB 159, please press star 9 to take your place in the queue.
Good morning, committee chair and members. My name is Luisa Benasano for the record, LuizaVenisano. I am the Campaigns and Community Engagement Manager for Planned Parenthood Votes Nevada, and we support AB 263. Thank you.
Thank you. Next caller.
Thank you, Chair. There are no other callers at this time. The public line is open and working.
Thank you so much. Then I will go ahead and open it up for opposition testimony, starting here in Carson City. Not seeing any. Broadcasting, will you open the lines, please?
If you'd like to testify in opposition to AB 159, please press star 9 to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you so much. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City.
Good morning. For the record, Teresa Benitez Thompson, Chief of Staff to Attorney General Ford. So as we read AB 159, we think that we have legislation that allows us to work on successful implementation of the program. Section 1, lines 7 through 9 about being able to consult and work in coordination with district courts and justice courts will be important to us. Also in Section 1, sub 2 for lines 32 through 34 about the flexibility and additional information that might be needed. And then section 4 on the time frames are helpful to us as well, just that upon passage and approval, we can begin the work, the administrative work, start those conversations about what this would look like, and then have actually until January 2026 to hit the ground running on this. So we think we've got a workable runway. We will mention, and we won't discuss it completely here, we don't think we need a lot of additional resources in order to make this happen from a practical standpoint. So you'll see a fiscal note, we think a humble fiscal note attached for one administrative assistant 3 position in order to do this. It looks like from the last report that we could find from the 2022 Uniform Crime Reporting Registry, there were about 1,700, just over 1,700 extended TPOs in that year. So basing it on that workload, we think with the one additional AA3 that we would be able to accomplish this.
Thank you so much. Is there anyone else wishing to testify in neutral? Not seeing anyone. Broadcasting, will you open the lines?
If you'd like to testify in neutral for AB 159, please press star 9 to take your place in the queue.
Good morning, Assembly Chair. Good morning, Assembly. Jason Gibson here out of Douglas County. We'd like the record to reflect that we are neither for or against this bill. We know for a fact, we have the evidence to show, and over 25 websites receiving 250,000 views a month, that most of our social ills and traumas and woes and damage controls, happening again this morning, are created by the state, manufactured by the state, and then cured by the state. We'd like to give you an example of such.
Okay, sir,
We
we're in
recently learned in our Board of County
Jason, we're in
Commissioner meeting-
testimony for the bill, so I'm going to ask that you speak
I'm
directly to the
testifying to the
bill.
bill. I'm going directly to this bill and the need for this bill. This bill is the result of well, for example, Douglas County receives up to 70 911 calls a day, emergency calls. Many of these calls are for protective orders or domestic violence issues or alleged emergencies. And what we learned is that the county here in Douglas County, a retirement community of 52,000 people, receives upwards of 500 calls a week, most of which are red flags. And law enforcement encourages the traffic and uses the statistic to pad their budgets and their salaries and their equipment requests and their expansion projects like the new Justice Center, 62 million plus, okay? So most of these calls are falsified. And when we try to get a protective order because the neighbor's shooting at our cats or what have you, then law enforcement comes out and tries to turn the narrative on us. And the next thing you know, we're the ones being slapped without representation, without due process, with an automatic protective order.
Okay, thank
They're
you, sir. Your
dishing
time
out
is
these
up.
protective orders like
Next
nobody's
caller.
business.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, thank you so much. Then I will welcome the bill presenters back up for any final remarks.
Thank you, Chair, and Committee. Melissa Hardy for the record. I just want to thank you for all the great questions and your interest in this bill. It would recognize the importance of protecting vulnerable individuals and empowering them to live free from fear. The Hope Card would be an effective mechanism for survivors to readily demonstrate their protected status and seek assistance when needed. A simple card given to a survivor to show they have an extended protection order could be the difference between life and death. I urge your support of this bill and thank you for your time.
Thank you so much for that. I will go ahead and close this hearing. We have another bill hearing. I just want to remind folks too that testimony on bills need to speak directly to the bill. Testimony on issues or things under the purview of this committee can be reserved for public comment. With that, our next bill is Assembly Bill 162, which establishes a statewide database and internet website for certain criminal records relating to domestic violence. So, Assembly Member, I will give you all a few moments to settle in. And then again, please remember, everyone needs to introduce themselves. And after you state your name, to please spell it for the record. And then when you are all ready, please proceed.
All right. Good morning, Chair Miller, Vice Chair Marzola, and members of my favorite morning committee, the Committee of Judiciary. For the record, my name is Toby Urich. That's Tobyyrek, and I have the distinct pleasure of representing Nevada's Assembly District 19. I really appreciate the opportunity to present AB 162 to you this morning, a bill that we hope to have recognized as Alessandra's Law. This bill is about equipping people with the tools they need to protect themselves, something that directly impacts public safety. Meeting new people has never been easier. Whether through dating apps or social media, relationships can form quickly, sometimes without much background or context. But what happens when somebody unknowingly becomes involved with a person who has a documented history of domestic violence, a history that isn't easily accessible to those most at risk? That's exactly what happened to Alessandra. She was a young woman with a bright future who unknowingly got involved with a man who had a history of domestic violence, including a prior attempted murder here in Reno. She had no way of knowing. 2 weeks after breaking up with him, he took her life. Had she or even her family been able to access the information that this bill attempts to provide, they might have recognized the warning signs and been able to take action. That's why this bill is important. Alessandra's law creates a statewide database allowing individuals to see someone they're dating and whether they had multiple domestic violence convictions. It's not about imposing additional punishment. It's about transparency and public safety. Today, you're going to hear from Michelle Afshar, Alessandra's best friend and board member of the Alessandra Foundation, who on behalf of Alessandra's parents will share their family's heartbreaking story. We will also hear from Katrina Esparza, a survivor from here in Northern Nevada who was targeted by this same perpetrator. And finally, we're going to hear from Liz Ortenberger, the CEO of SafeNest, who will speak on the cycle of abuse and the ongoing threat that is posed by repeat offenders. And then I will conclude with a short section-by-section overview of the bill before we address any questions that the committee may have. So, Chair, with your permission, I would like to turn the microphone now over to Michelle.
I've never done this. Michelle Afshar, Michelleafshar. Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. My name is Michelle Afshar, and I'm here today not only as a member of the Alessandra Foundation, but as Alessandra's best friend. She was my sister in every way that mattered. And losing her to domestic violence nearly 10 years ago shattered many lives. But since then, we have fought to ensure her story is not just one of tragedy, but one that sparks change. For nearly a decade, Rick and Diane Beatty have dedicated themselves to shining a light on the dangers of domestic violence. They have traveled to courtrooms, legislative chambers, and communities across the country. They're sharing Alessandra's story and fighting for laws that could save lives. They have never hesitated to stand before lawmakers, no matter how painful it is to relive their daughter's murder, because they believe in this work with all their hearts. That's why it's especially difficult for them to not be here today. Due to a medical emergency, they were unable to travel for this hearing, and something they would never miss under any other circumstances. They have asked me to stand in their place and read their statement to you now. Their words will follow. Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. My name is Rick Beatty. My wife Diane and I are the co-founders of the Alessandra Foundation, created to honor our daughter, Alessandra Barles, who was brutally murdered by her ex-dating partner in October 2015 in San Jose, California. We moved to Las Vegas from San Jose in 2021 and are deeply grateful to Assemblymember Urick for collaborating with us to bring forward AB 162, Alessandra's Law. It is our hope that this legislation will protect other families from facing the unimaginable loss that we experienced. Why we need this legislation. The man who murdered Alessandra, now serving a life sentence without the possibility of parole, had previously attempted to kill another dating partner in 2009, right here in Reno, Nevada. She miraculously survived that brutal attack and thankfully is here with us today. Unfortunately, neither our family nor Alessandra had any idea of this individual's harbored such a violent history. He never disclosed his past, and in the absence of any accessible tool to uncover domestic violence convictions, we were left entirely in the dark. By the time we learned of his criminal record, Alessandra was already gone. I can't say with certainty that an online conviction database or record portal would have prevented Alessandra's murder, but I do know it would have given us and her circle of friends vital knowledge. Alessandra had already broken up with him and was preparing to move on with her life. She had just been accepted to Samuel Merritt Nursing School 3 days before she was killed. Lured under false pretenses to an apartment in San Jose where she believed she would be repaid money he had borrowed, she was attacked and left for 3 days while he fled. The Alessandra Foundation. Diane and I have a strong faith in Jesus Christ, and from the very beginning, we felt guided to turn our grief into action. About a week after Alessandra's passing, I felt the Lord prompting me at 2 a.m. to create a foundation in her name, a foundation that would carry on her vision of serving others. Alessandra's name means helper and defender of humankind, and we are determined to honor that calling.
Our work has two main focuses: education and advocacy. In 2023, we collaborated with Texas Representative Victoria Neve Criado and Dallas Police Chief Eddie Garcia to develop Texas HB 5202, which established a public-facing database of individuals twice convicted of domestic violence. That legislation passed with overwhelming support. When my wife and I met Assemblyman Urick at a Las Vegas Chamber event, we shared Alessandra's story and the success in Texas, and we soon began drafting a Nevada version of that law. With guidance from the Nevada Coalition to End Domestic Violence and Sexual Violence and numerous service providers, AB 162, Alessandra's Law took shape. Our request: on behalf of my wife, Diane, the Alessandra Foundation Board of Directors, our extended family, and the many friends who loved Alessandra, I humbly ask for your support of AB 162. Passing this bill would provide greater transparency, potentially preventing other families from enduring the horror of losing someone to a brutal and senseless crime. Thank you all for your service to the people of Nevada. May God bless you and grant you wisdom as you deliberate this legislation.
My name is Katrina Esparza, Katrina Esparza, and I stand here before you today in support of AB 162, or Alessandra's Law. I feel compelled to share my story because the man who murdered Alessandra once tried to kill me too. I hope my experience helps sheds light on why this legislation is so crucial. If I can't have you, nobody can. Those are the words spoken to me by someone who I loved and I trusted, still echo in my mind. I was new to the area and he was all that I knew. In hindsight, I see how isolated that made me, easier to manipulate, control. I was stalked as well. I tried to leave thinking I had finally broken free, but he showed up one night telling me more lies to earn my trust. Then without warning, he turned violent. He went in for a hug and started to stab me with the kitchen knife, strangling me and attacking me. I remember the blood and the sheer terror of knowing I might not survive. By the grace of God, I did survive. But Alessandra tragically did not. The difference might as well have been the ability to check his documented history of domestic violence. That is what Alessandra's Law would do. Give people free and immediate access to vital information about potential violent past. Domestic violence can happen to anyone. It's surrounded in shame, and many victims blame themselves for not leaving sooner or not warning others. This bill would help prevent future heartbreak by ensuring the young women and anyone else facing similar situations have the tools to protect themselves. If we can help one person avoid hearing the words, "If I can't have you, nobody can," it will be worth it. I respectfully ask for your support in AB 162. Let's all stand together, protect those who are isolated, vulnerable, and in need of life-saving information. Thank you.
To both of you, thank you so much for your courage to come and share your stories. We are deeply upset about both of your losses. To the parents, we extend appreciation for their advocacy and their courage as well, and hope that whatever situation they're addressing right now comes through on the positive side. And to you, a survivor, thank you for your courage. Both bear different wounds, and hopefully they can close a little more as time goes on. Your loss of safety and security is something that we do recognize. But thank you so much for coming forward and sharing your stories.
Thank you. Liz Ortenberger, for the record, CEO of SafeNest, and I echo Chair Miller's outstanding delivery of bravery that it takes to come forward in the face of domestic and sexual violence. I'm going to provide a trigger warning before I speak. I'm going to share with you 4 homicides from January 2023 in Clark County. Rachel Ruiz Izquierdo, 25 years old, killed January 4th, 2023, in a suspected murder-suicide with her boyfriend. Cause of death, gunshot wound to the head. Janet Rivera, 41, found strangled January 28th, 2023, in her Southwest Las Vegas bedroom. Cause of death, strangulation by choking on a foreign object. Shirley Williams, 56, found strangled on January 29th, 2023, in her Southwest Las Vegas bedroom. Cause of death, strangulation. Ashley Benitez, 22, fatally shot on January 31st, 2023, inside her apartment after a fight with her boyfriend. Cause of death, gunshot wound to the neck. These are simply 4 homicides in Clark County in 1 month of the year. We know that we live in one of the most dangerous states in the country for women being murdered by men, and one of the most dangerous states in the country for domestic homicides in general. I, like these women and Alessandra, have no idea if the perpetrators had been prior convictions of domestic or sexual violence, simply domestic violence. What we know about domestic violence relationships is they start out in a normal pattern. It's dinner, it's conversation, it's texting. And then that friendly text that said, please text me when you get home, becomes a text of, please let me know when you leave work. Please let me know when you leave the grocery store. Please let me know when you get home. You're not home on time. You're 5 minutes later than you're normally home. And slowly the walls of control close in around a survivor who started a relationship, falling in love, and having romance the exact same way that we all do. And then what we know is the most dangerous time for a survivor of domestic violence to be murdered is as they're preparing for departure or in the 0 to 12 months after they have left. Nevada remains one of the most dangerous places in the country for women being murdered by men and domestic violence, homicides in general. This bill gives potential survivors at least one opportunity to check upon 2 convictions, which as your premier agency in the state, I don't know what that number is of how many convictions folks have over 2 years, but I will guess the number is relatively small. Because what we know is when domestic violence perpetrators are issued classes, there's a stay of charge. So if you take the 26 weeks of classes, you are not convicted of domestic violence. So the list of convicted domestic violence perpetrators that would be on this list are those that either did not engage in classes, did not complete the classes, and received 2 convictions within a 7-year period. These are our most dangerous abusers. Let's give potential survivors the opportunity to live, and let's pass this bill. Thank you.
Thank you, Chair. Toby Urick for the record. If you're good with it, I'd just do a quick overview section by section so that the committee has a chance to understand what's going on in this bill. Section 1 amends Chapter 179A of NRS to include the new provisions that are set forth in Sections 2, 3, and 4. Section 2, Sub 1 requires the Director of the Department of Public Safety to establish a statewide database within the central repository for persons with 2 or more convictions of domestic violence. Subsection 2 of Section 2 clarifies that the database must provide certain information about each person, including their name, date of birth, physical description, offenses, and punishment. Subsection 3 clarifies the database is public, but certain confidential information, such as social security numbers and victim identities, is excluded. Subsection 4 provides an internet website must be maintained to provide public access to this database information. Subsection 5 ensures the website must include information on the process for petitioning for the removal of information, as well as contact details for organizations that provide services to domestic violence victims. Subsection 6 allows individuals to petition for the removal of their information under certain conditions. Subsection 7 requires the director to consult with organizations that provide services to domestic violence victims and use existing databases where feasible. Subsection 8 provides immunity from liability for the department and for law enforcement agencies regarding the accuracy or disclosure of information. Getting into Section 3, it prohibits the use of information from the database for purposes related to loans, credit, employment, education, housing, or business services. Section 4 establishes civil liability for anyone that uses this database information in violation of Section 3. Section 5 and 6 offer conforming changes to clarify that public information from the database is not subject to dissemination restrictions and address confidentiality and public record statutes. With that, Chair, we are open and willing to address any questions that the committee may have. Thank you.
Thank you so much. With that, we will open up questions, beginning with Assemblymember Gray.
Thank you, Madam Chair. Good morning, Assemblyman Yerrick. Another good bill. Why did you decide to include misdemeanors instead of just limiting it to felony convictions?
Liz Ortenberger for the record. So, data is not easily available in this state around convictions for felonies or misdemeanors. And what we see as a trend is very often felonies are being pled down into the misdemeanor space. Part of that is lack of access to forensic nurses for strangulation exams in particular, which would carry a felony offense, but the evidence isn't available. Part of that is also has to do with survivor recants and no-shows as they relate to different cases. So while I would love to say, hey, this should just be a felony database, I think what the numbers are showing us and what the survivor experience and the abusive partner experience in our justice system is that being convicted of 2 misdemeanors in 7 years is already a high bar. And let's do the best we possibly can to get this space as safe as possible.
Chair, if I might as well, Toby Yerrick for the record, would you prefer I go direct? Okay. I appreciate that question. And anticipating this, by the way, there's been a lot of dialogue. I've been working this bill for over a year and understood and anticipated that issue might come up. And so while I don't have all of the references, I'm happy to share with the committee the data that I did find to support that. But the reality is, as I believe Liz just indicated, is that most domestic violence cases are charged, in fact, as misdemeanors. So even when they involve serious, more egregious bodily harm and injuries, and so, for example, I know that the Bureau of Justice statistics say that about 80% of domestic violence arrests result in misdemeanor charges. The NIJ indicates that misdemeanor domestic violence offenders still have a very high rate of recidivism. And then the CDC found that strangulation is a predictor of future homicide. Strong correlation there, is often charged as a misdemeanor. So ultimately, if we limit the database to felony convictions only, my concern is that we'd be excluding from that database the people that are most likely to recidivate, reoffend, and potentially hurt somebody.
Thank you. So,
I'm going to have legal jump in. Ms. O'Krent will respond to that as well.
Carly O'Krent for the record. Under NRS 200.485, DV battery is a gross misdemeanor offense.
Thank you. Our next question will be from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this bill, and thank you for your bravery in telling your story and Alessandra's story. My question is about the cross-state nature of the story you just told us. If this database is Nevada-specific, how will women in other states get that information? Will this be part of a national database? Will women have to search literally every single state to see if something happened?
Liz Ortenberger for the record. So first of all, SafeNest data shows that 80% of what's happening here is grown here. So know that yes, while Alessandra's case is tragic in that the abusive partner moved to another state, and so what we will advise is that folks look at the databases that are available. Currently, it would be Nevada and Texas. So if you have an abusive partner who is coming from Nevada or Texas, you'd have availability of the database to look. There is no national database around this. The only way you could achieve this information would be to buy a national background check through the FBI or one of the background check companies. So currently, that's how that would have to progress. So if you had an abusive partner who had roots in Nevada, you would be able to check the Nevada database.
Thank you for that. clarification. So my follow-up question is just about how women would know about this, because I don't know that many women in starting a new relationship know, I should look up the domestic violence database. So is there a plan to advertise that should the bill pass?
Liz Ortenberger for the record. So I can only address this from SafeNest's lens, but as we intersect with 11,000 plus survivors each year, of course it will be part of our education portfolio. The other thing, should the bill pass, what we will plan to do in Clark County in particular is work with our partner agencies, Legal Aid of Southern Nevada, our sister agencies in the adjacent space, and work on a marketing and advertising campaign. We also have cards that are provided on the scenes of many domestic violence 911 calls, adding some information about, hey, you can check this database, but it will be survivors in communities share information with each other. So it will be about getting the information out and then about making sure we're persistent in sharing it. The other thing I like to share is a lot of the survivor families that we work with are parents of adult children who have a daughter inside a relationship they feel like they can't get to her because she's been isolated. Allowing those and educating those parents on the availability of this information is hugely helpful as well. So it will be a grassroots marketing effort on our end. There may be something larger that the state can provide in terms of money for a marketing campaign, but certainly that's how we plan to do it.
And Chair, if I might, for the record, Toby Urick, I really appreciate that question. And honestly, it's one of the questions that I wrestled with is, and I think the reason I appreciate it, because it sounds like you appreciate the value of a database like this and how it will help people. But the reality is certainly people do cross lines, as this specific story indicates. My hope is that through the advocacy efforts of this family, that we might be able to step into this space and really start to launch a trend of states that can grab onto this and make this information more readily available. And so that is kind of our hope. I recognize our limitations as state legislatures. I would love to see this take on a national level, but I'm hopeful that we might be able to be the next step to really kind of push a trend across our country. Thank you.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you so much for being here. And again, to reiterate, I think I speak on behalf of all of us that we admire your bravery. We're so sorry to the Beatty family for the loss of Alessandra, and we should all have good best friends like you and a strong survivor that is willing to come and relive some of the horror of your experience to help others here in Nevada. Appreciate you all. I was just interested to understand within the bill, it's all domestic violence, not just intimate partners. So maybe if you could elaborate on why it went that route.
Liz Ortenberger for the record. So of course it follows the statute definition of domestic violence, which makes everything cleaner because then the department that's setting up the database has very clear guidelines around what's included. But I will also, working in this field, domestic violence, yes, it's in the intimate partner space, but pre-indicators oftentimes sit in a very different space. They can sit in the family space. They can sit in an adult child abusing an adult parent. That violent nature, while we often identify it in only the intimate partner space, is absolutely in 40% of the domestic violence that we deal with on an annual basis is not intimate partner. So I think in order to make the database the most effective and ensure those administering it have the cleanest guidelines, following the NRS definition of domestic violence makes the most sense.
And Chair, if I might as well address that, because that is another one of those issues that as I was working on this bill came up as, well, it seems like most of these issues are often involving the intimate partner violence. And so I also tried to go and research and understanding there's not a lot specifically here in Nevada, but nationally, the decision was made to broaden the scope to include all repeat domestic violences, whether or not it was intimate partner or not, because violence that is within the families often extends beyond just that of the intimate partners. And so to cite just a couple of stats for you to help highlight or illustrate this, the Department of Justice shows that 30 to 40% of domestic violence offenders have a history of abusing multiple household members, including children, parents, siblings, not just intimate partners. The National Domestic Violence Hotline found that abusers who harm other family members are more likely to commit severe violence against intimate partners later. And finally, CDC, domestic violence within families beyond just intimate partners often correlates with higher rates of homicide, child abuse, and elder abuse. So what we see is a consistent pattern of violence that extends beyond that of intimate partners that often does come back. And so believing that those stats and violence outside of intimate partner is a predictor of what might happen to an intimate partner is what led us to really include that language in this bill.
Thank you so much for that. Our next question is from Assemblymember Roth.
Thank you so much.
Yeah. That was the media, just for everyone's edification.
Thank you so much for the presentation, and thank you both so much for sharing your story. I don't think there's probably anybody in this room who hasn't been impacted by domestic violence in some way. A concern I raised earlier on a bill earlier in the week is that I often interact with victim survivors in a different space, and that's when the legal system has been weaponized against them. And so that always kind of, sits in the back of my mind. And so with that, my question is, have we seen in places that we have implemented this, that there has been a reduction in violence, so that we can really balance, how the legal system sometimes interacts with victim survivors in a not so great way with the need to reduce that violence?
Liz Ortenberger for the record. As the Texas law only went into effect last session for them, so 2023, there is limited data as to know whether or not violence rates have dropped. Also, to understand the cycle of violence, it is not my anticipation that this bill would create violence rates to drop. And the reason is because while I may be educated about the database and I can look that up as one survivor, as Assemblywoman LaRue Hatch mentioned, how does everybody know about it? And that's going to take quite a bit of time. So an abusive partner and the abusive partner traits are, okay, I'm going to maybe find you as my next potential partner, and you may be then educated about the database, and you may exit that relationship before either engaging or early. That abusive partner is still going to seek another partner, and someone who doesn't know about the database or for whatever reason engages in that relationship is going potentially to become a victim. So bills like this are incredibly important for protecting the space, but they won't reduce violence. I think that that's important to understand. Unless every woman for whom this perpetrator was aware of the database and decided not to engage, right, which would be all the women in the country, which seems improbable. So just understand the nature of this is to protect a potential survivor, but it isn't going to do anything to curb violent rates. As you speak about the justice system being weaponized, we actually have a series of classes for people that have been convicted of domestic violence, but whom we can see through the assessments are absolutely the victim. So no, if they engage in the classes, that conviction is dropped from their record, so they wouldn't be in the database, right? So again, the high bar of getting in this database should control that weaponization, and also, anything else that we're concerned about, because 2 convictions in 7 years in this space is an incredibly high bar.
And I would just like to, because I know that Ms. Ortenberger doesn't mean to imply that men are not victims. We appreciate and understand and know it's even more sensitive, but men are indeed victims from women, and they are victimized from men as well. And so we, of course, want all of our male victims to please come forward, because we want to support them as well. With that, our next question is from Assemblymember Moore.
Thank you, Chair. And thank you for being here, sharing your sister's story and your story as well. I think those of us that are survivors need to speak up more. But I do have, given my personal experience and what we've heard in the past, is that abusers don't often get arrested immediately. It takes several phone calls for that to happen. And a lot of times, if it's the first time, right, they're in a relationship with someone else. They did the same thing. They were never arrested. They're in another relationship with someone else, and they finally get arrested. A lot of times, nothing happens to them. They take classes. They do community service. They may spend a night in jail, if that. So they wouldn't be on this database. And I just want to know, in order to be in this database, they have to be convicted twice. Do we have an estimate of how many people would be on that database here in Nevada?
Thank you, Assemblymember Moore, for that question. Toby Yerk, for the record. I'll let Liz address that in a second if she has some data, but I'm not aware of truly how many people this would be, but I think you've highlighted a point that I really want to emphasize here, and that is the high threshold of 2 convictions. That's why, as I alluded to earlier, we didn't limit it to like felony. I mean, to get to the felony, that's off the charts high. This is not going to capture every potential violent person out there that poses a threat to somebody. But what we're trying to do is strike a balance from a public policy perspective of providing transparency and maintaining an individual's right to be free from, additional, punishment and hurdles that could stigmatize them and create problems. And so that's the balance that we're trying to do here. And so, again, I want to reiterate what I think your point is making, and that is we're not going to capture everybody in this database. This is not a be-all, end-all solution to domestic violence and progressive, more serious injuries, ultimately death that can happen from these. So I don't know the number of people that it would, and perhaps Liz can speak if she's got some specific data on it, but I just wanted to reiterate that point, that this is trying to strike that balance.
Liz Ortenberger, for the record, and I did want to thank Chair Miller for that. 30% of the arrests in the domestic violence space in the state of Nevada are female perpetrators. So just to give everybody context, 70% male perpetrators, 30% female perpetrators is the numbers that come out in the Nevada crime stats. To answer the question, so there is complexity around the data in the space in that it is not publicly available. We tried to, through the AG's office several years ago, get reports from the courts on how many convictions are we actually having. So my data just comes by way of, if you are convicted twice of a domestic violence misdemeanor, you are issued 52-week classes instead of 26-week classes. As Safeness is a provider in that space, I can tell you that I have had 2 people in my 8 years at SafeNest that have been issued the 52-week classes. And that's the only indicator I have of how many folks have been charged twice in a 7-year period with domestic violence. Thank you.
Thank you for that. Our next question is from Assemblymember Gonzalez.
Thank you so much. As a victim survivor myself, I really appreciate the intent of this bill. My question is, if people were to seal their records, but they're on this database, do they then petition to get off this database? Is this something forever? Kind of talk to me about what those logistics look like.
Thank you, Assemblymember Gonzalez, for that question. Toby Yerk, for the record. To be clear, that is specifically what this bill does allow, is for somebody to petition to have themselves removed from this database. That can be basically one of 2 ways right now, and that is that if they were to have one of their records, convictions sealed or expunged or removed, and it would put them below the threshold of 2 conviction requirement, they could petition to have themselves removed. And then the other way is that a conviction, or for lack of a conviction within 7 years, they can also petition to have themselves removed. So under both of those circumstances, they just file that petition. The process is not fully vetted out yet. They'll probably have to establish through the regulatory process, but that would, the intent would let them petition to have themselves removed under those circumstances.
Thank you so much for that. And then, because I'm just thinking of like the courts and like victim impact statements, would that be taken into consideration if a perpetrator is asking for their information to be removed from the database?
Thank you for that question. Toby York for the record. I didn't anticipate for purposes of removal from this database that there would be that, because we're really trying to make it pretty clear and concise that under these specific circumstances, your removal. Obviously, to have records expunged and certain, Marzi's law, constitutional requirements, certain victims would have the right to speak into processes that would precede this petition to have themselves removed.
Thank you for that. Our next question will be from Assemblymember Gray.
Thank you, Madam Chair. Ms. Ortenberger, you've mentioned in your testimony several times that the 7-year mark, which we've seen in the bill. So I'm going to direct this one actually to Assemblymember Urick. Why 7 years? Why not 10? Why not 5? Speaking as a father, I think longer. A father of 2 daughters, I think longer better, but that's just me.
Thank you, Assemblymember Gray. Toby York for the record. It wasn't long ago that we were sitting in this committee and there was, on a related bill, a look-back period that sought to extend from 7 to 10 years. And so, anticipating that, I also went and was trying to look and try to figure out why is that, because I wasn't fully aware. There was some intuitive sense that it made, but I really appreciate, because I didn't highlight that point earlier, but basically it's based on statistics and research related to criminal recidivism, and specifically the point at which a person's past convictions statistically mean that they're less likely to reoffend. And so basically studies show that after 7 years without a new conviction, an offender's likelihood of committing another crime drops significantly and approaches that of basically the general population. And so I did find, for example, a study here from the Bureau of Justice Statistics. It was a 2014 study tracking over 400,000 released offenders. They found that more than half, or 53%, of domestic violence offenders were arrested again within 3 years. By year 7, recidivism rates dropped to that, basically correlating with the general population. There was another study that I found, a 2021 study by the National Institute of Justice, that found that repeat domestic violence offenders were at the highest risk of reoffending within the first 3 to 5 years after their convictions, with rates again statistically dropping off significantly at year 7. And then finally, I found one more here. It's a 2017 study by the U.S. Sentencing Commission that found that recidivism rates fall sharply after 7 years, indicating again that the offenders who have remained crime-free for a period of 7 years are just much less likely to reoffend. And so that's why I did not choose to expand this any further.
Thank you for that. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. This is very important matter, and thank you for bringing it forward. So my question is that the same person who is convicting the crime again and again, it indicates that that person has some mental issues, some issues maybe his relating to the childhood or growing up. So do you include, do you think about including a therapy, some behavior therapy going forward?
Liz Ortenberger for the record. So what is now currently available for someone that is at misdemeanor domestic violence is 26 weeks of classes. Those classes have a list of requirements in the NRS of what needs to be provided. They are group classes and they are facilitated, not therapeutic, but it is the closest thing that we have to mental health for this population. I also think it's important to understand the intersectionality of domestic violence and alcoholism, the intersectionality of domestic violence and child abuse are all there. The classes are designed to deal with that intersectionality and work with each offender to find ways to mitigate their violent tendencies. So that's what's available currently. If you're convicted once in that 7 years, you get 26 weeks. If you're convicted twice, you get 52 weeks. So that's the current layout. We have looked at mental health, individual therapy, and things for abusive partners. As you all know, Nevada is hamstrung in how many therapeutic providers that we have. This is a space that if you are running this program, you are reliant on the offender paying for those classes, or as SafeNest does, we underwrite the program $250,000 a year. So understand this is a very complicated space, not only for abusive partners, but also financially for providers.
Thank you.
Thank you so much. Assemblymember Hanson, do you have a question? Okay, thank you. All right, with that, that concludes our questions. So I will open it up for testimony. We will first begin here in Carson City. Again, I ask that those testifying, please say your name and spell it so we have it correct for the record. And please keep your comments to 2 minutes each. We will begin here in Carson City with support testimony. And yes, please feel free to fill the chairs and just rotate yourselves out.
Hi, my name is Maximilian Lowe, Maxmillian. My last name is Lowe, Lowe. I'm here to support AB 162 as I strongly believe that public safety and the safety of domestic violence and sexual assault victims should be top priority. And one thing I would like to hope that if this bill passes, that the regional centers that provide services to those with disabilities have access to this database, because Desert Regional Center, where I left Las Vegas, I believe I can't exactly give the numbers because they keep these statistics secret, is that I believe there's at least a third of the clients that receive disability services with the Desert Regional Center have a violent history like this, and there is a service coordinator who specializes with that, who I know, and that the situation with my ex-roommate who's abusive would say, oh, when I report things to the service provider I was with back in Vegas, and that they would say, oh, it's just two roommates, you get along. But over time, and when I would say things, tell them, report things, it would not be believed. And it had led up to the situation that I told you about before, and that had I not made that APS report, had I not made that police report and pressed charges against my ex-roommate, nothing would get done. However, there are investigations. Also, I would like, if this bill passes, I hope that it would help other people and the service providers and the service coordinators to identify when they assign housemates in the service providers, is that understand who should be with who and what the level of care and supervision. Thank you so much.
Good morning, Chair Miller, members of the committee. Alex Kaneda with the firm Womble Bond Dickinson, formerly known as Lewis Roca, on behalf of the Domestic Violence Resource Center. I wanted to share a personal story with you this morning. A few years ago, I matched with this guy on one of the dating apps, went out with him, actually knew of him from my undergraduate studies at the University of Nevada, Reno. Later found out that he was on parole because he had served time for charges of attempted murder, false imprisonment, and strangulation of a girl that he had dated for a few weeks. A database like this, I think, is really, really important. The apps don't do background checks, to my knowledge, on the people on them, and I think it's really important that we know who we're, involving ourselves with, who we're going out with, because when you're going on dates, you're meeting strangers, you don't know anything about them, and you only know what they, tell you. So we support this bill. Thank you.
Good morning, Chair Miller and members of the Judiciary Committee. My name is Elizabeth Abdur-Rahim, ELIZABETH ABDUR-RAHEEM. I am the Executive Director of the Nevada Coalition to End Domestic and Sexual Violence, and I am pleased to speak in support of Assembly Bill 162. Last year across Nevada, 49 individuals died in homicides related to domestic violence. One of the most devastating things that we must realize as a state is that many of these deaths could have been prevented. As we have heard, the sobering reality is that many abusers do not stop when the first or second relationship ends. Instead, their relationships are a consistent path of power, control, and violence, replicated across time. When these individuals are intercepted by law enforcement and the criminal justice system, there is an opportunity to recognize the pattern and prevent further abuse. The most basic tenet of advocacy is to listen to victim survivors and understand that they are the truest experts in the field. When victim survivors of domestic violence and their families come together in the midst of their personal trauma to identify and fight for a solution that will save others, we must listen and implement these solutions. This bill is one of those times. We commend the personal bravery of the victim survivors who are sharing their stories here today. We commend Assemblymember Yurick for listening to victim survivors and acting on their behalf, and we urge you to support Alessandra's law.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. We are in support of Assembly Bill 162, Alessandra's Law. We appreciate her family and friends, as well as Assemblyman Yurick, for bringing this bill forward. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, JASON WALKER, representing the Washington County Sheriff's Office as well as the Nevada Sheriffs and Chiefs Association, supporting AB 162 for all the reasons outlined in the presentation.
Hello, Chair and Committee. Jessica Glover, JESSICA, Glover, GLOVER. I am supportive of AB 162. I think it's very important to establish a database for internet websites for criminal records. And I applaud the friends and family of Alessandra coming forward. My personal experience is I did meet someone that was online, and when they became secretive, I used my own legal research and paralegal studies, and I started researching them, and I found out that they had been to prison and they were on parole for either murder or drug trafficking. When I ended the relationship, they started having their friends and family started harassing me and stalking me, and I went to law enforcement, and law enforcement was not understanding what I was going through. I ended up committing a crime that I had to fight and acquit from, and that saying of, if I can't have you, no one else can either, is a true and real thing. My abuser wanted, if they couldn't have me, they either put me 6 feet under or in prison. So I recommend AB 162. Thank you.
Thank you. Not seeing anyone else here in Carson City. I did see someone in Las Vegas. I just want to make sure. Is there anyone there wishing to testify in Las Vegas? Okay, not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in support of AB 162, please press star 9 to take your place in the queue.
Jason Gibson on behalf of the Foundation for the Law of Time. We're in support of the bill. It's necessary to provide a context for testimony, however, so please be patient. One of the callers, I quote, "Domestic violence knows no boundaries." All this damage control this morning, the historic sum result of economic slavery, commercialism, prostitution, ignorance, greed, cultural genocide. It's manufactured by a fictitious entity doing business as the state of Nevada. These kinds of systems are going to be a reoccurring theme as we look at the violent social fabric of one of the wealthiest states in the country. Follow the money. These remedies that we bring to the table again today, which augment these kinds of legislative bills, have been online for over 85 years. Well, this is knowledge that's been on the table for over 85 years. The constitutional crisis, folks. It's rooted in education. Many of the people in this state are well-to-do and have a very low social IQ. And if you did a little social networking to find out about your potential partners or relations, like use your Facebook, you can tell all sorts of
Okay,
things about a
sir,
person.
we are
before an
not going to
incident becomes
condemn
a
victims.
tragedy.
Next caller.
I'm not condemning.
Thank you, Chair. The public line is open and working, and there are no callers at this time.
Thank you so much. With that, I will open it up to opposition testimony here in Carson City. And again, I just want to remind folks that opposition testimony is not opposition to the issue, the concern, or the experience of victims. It's opposition to technical aspects of the bill and the policy.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, Clark County Public Defender's Office. My testimony in opposition is by no means an attempt to minimize the loss of Alessandra. She should be here today, and I'm very sorry to her parents and everyone that loved her for their loss. A DV database like this, at this point, is premature. The bill was copied from an identical bill that was enacted in Texas. However, it's been too early to see if there's been an actual impact in Texas and see if it will actually help possible survivors. So we don't know at this point if it will do more harm than good. The Washoe County PDs and I have spoken with Assemblyman Urich about our concerns, and we thank him for reaching out to us to hear what we had to say. First, the intent of the bill is to help with intimate partner violence, but the bill as written encompasses more than intimate partner relationships. It includes any person whom the person is related to by blood or marriage. And if we think about the world that we're living in now, where children are spending more and more time living at home, there gets to be a ton of friction between children and their parents. So we don't really want to be including those situations, because at this point someone can be 19 years old and push their dad, get their first DV conviction, and then at 25 years old be a victim of DV themselves, call police for help, police show up, they can't tell who was the first aggressor, be mistakenly arrested themselves and get their second DV conviction. And now they're on a public database themselves for everyone to see. So we did suggest an amendment to limit the definition of domestic violence to just that intimate partner relationship. Second, I want to make clear that this bill cannot be retroactive. We can't put on a public website the names of anyone who has already been convicted, because the law requires that when someone takes their plea, they make an informed decision. And since no one was admonished and advised that this would happen, doing so would be unconstitutional. And third, instead of a petition-based process for getting people off the database after 7 years, we suggested that the database just make it automatic, because people are unlikely to be tracking when 7 years has elapsed, and take all of the steps to actually get themselves out the database. And I'll pass it to my counterpart from Washoe.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. Our next concerns when we spoke with Assemblyman Urich is how misdemeanors and felonies are significantly different. A second domestic violence conviction within 7 years is still a misdemeanor. Basically, a daughter who pushes her mom when she is suffering from a mental health episode when she is 20 years old can get her first domestic violence conviction. And then 5 years later, when she pushes her mom again, she will get a second domestic violence conviction. That young woman will now have her information and her picture blasted on this website. That seems to be against the spirit of this bill. Domestic violence calls for mandatory arrests, and oftentimes, due to the chaos of the situation, it's the victim that is arrested. We have concerns that focusing on misdemeanors wraps in victims of domestic violence, where the legal system is being weaponized against them, while ignoring the verifiably violent offenders. Amending this bill to reflect felony DV cases encompasses the more dangerous and violent offenders, ensuring state and county resources are dedicated to the most high-risk offenders. And just to clarify, in Washoe County, I am unaware of any practice or law that reduces a second domestic violence conviction to a first if they complete counseling. Lastly, while this bill attempts to include protections against misusing this information against a person, it will absolutely be used against that person. Rental companies will be checking the websites when filtering through applicants and deciding who gets to have a home. And potential employers will be pulling this information from the website to reject employment for that person. We would like to continue working with Assemblyman Urich in crafting a bill that captures the spirit of Alessandra without the unintended consequences. Thank you.
Thank you so much. Is there anyone else here in Carson City wishing to testify in opposition? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
If you'd like to testify in opposition to AB 162, please press star 9 to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you so much. Then I will open it up for neutral testimony. If there's anyone here in Carson City that would like to testify in neutral.
Good morning, Chair and committee members. My name is Nicole Riley, Nicolereilly. I'm the Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking at the Attorney General's Office. I just wanted to add on the marketing piece, that if this bill passes, the Attorney General's Office will be very happy to work with all of our partners statewide to disseminate the information.
Thank you so much. Broadcasting, will you open up the lines for neutral testimony?
The public line is open and working. There are no callers at this time.
Thank you. Then I will welcome the bill presenters up for brief final comments.
Thank you, Chair and committee members, for this very thoughtful discussion on what I believe to be a very significant and important policy issue. I also want to thank the public defenders who came up in opposition today. We did have a meeting. We've had subsequent and follow-up conversations, and while I appreciate their perspective, they did submit a conceptual amendment to me last night, and I let them know that in consideration of what we're trying to do and trying to find this balance, that it would be, from my perspective, an unfriendly amendment. I of course, until we get a work session, move this out, of course, I'm willing to continue to have discussions to see if we might be able to address any issues that they have. But I just want to, again, thank them for their discussion and willingness to have conversations with me about this. In closing, I just want to say that this is a difficult issue, right? Domestic violence is a massive issue and it's a difficult issue in our state. And I understand the public defender's concerns about misdemeanor versus domestic violence, the scope beyond intimate partners, as well as why we're requiring a petitioner to, or somebody to have to petition to have themselves removed as opposed to just an automatic removal. And to be sure, I believe those are fair questions, and I believe that they deserve honest answers. And so in my closing, I just want to briefly address it and say that, well, the reality is that domestic violence isn't always charged as a felony, even when it should be. Most domestic violence cases, serious ones included, are pled down to misdemeanors. And if we limit our database to felony convictions only, we risk leaving out the very people that are most likely to reoffend, putting the very victims we're trying to help in danger. Domestic violence isn't just about intimate partners. The data shows that abusers harm family members, children, parents, and even siblings. They're just as dangerous in future relationships. And so we can't turn a blind eye to these patterns of violence just because they don't fit into a very narrow definition. Abuse is abuse, and if we want to prevent future harm, we have to acknowledge the full scope of that problem. And then finally, I understand the concern about requiring the petition for removal as opposed to automatic removal, but this is about getting it right. And automatic removal could lead to mistakes, allowing people to slip through the cracks even when they still pose a threat. I was thinking about this as an analogy earlier. Sometimes we put spam filters on our email and we want certain things to happen in an automatic fashion. And my guess is, as I look up on this dais, a lot of you can find out that automatic processes don't often work as efficiently we'd like. And so we just want to make sure that a process doesn't allow the people that we're trying to hold accountable here or to help protect our victims, they can't slip through the cracks. So at the end of the day, this is about giving people access to information that could save lives. Domestic violence is not just a moment in time. Like I said, it's a pattern, and we have a chance to intervene before that pattern escalates into something worse. So I urge you to support this bill, and I thank you for your time.
I just want to say on behalf of the 49 victims of domestic violence homicides last year, the 56 in 2023, and the countless before them, this is an opportunity for our state to do something for survivors. Thank you.
Thank you so much for your presentation, and we just have a final statement from our Vice Chair Marzola.
Thank you, Chair, and thank you, Assembly Member, for bringing this bill. It's an important bill because it makes it available for everyone, information that should be out there. If I have the means and I can afford it, I can buy a subscription, go on the website, and find all sorts of information about anyone I want. But I think the reason why this bill is important is it makes it available to everyone in our state, no matter what zip code, if you have money, if you don't have money. And so this is why it's important. Thank you so much for bringing this bill. And Liz, thank you again.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 162. Next on the agenda is public comment. Again, public comment is not to comment on the bills we just heard, but to comment on issues that are under the purview of this committee. So I will open it up first for public comment here in Carson City. Not seeing anyone. Broadcasting, will you open the lines?
If you'd like to provide public comment, please press *9 to take your place in the queue. Chair, thank you. There are no callers at this time.
Okay, thank you so much. Then I will close public comment. And with that, I will go ahead and adjourn the meeting as we have completed everything for today. And I know that everyone is anxiously waiting to find out which time we will start on Monday morning. All the eyes and heads are turned. So with that, we will start at 9 a.m. on Monday morning.